Good afternoon, colleagues, ladies and gentlemen. You don't quite need to stop your conversations yet. I'm really here because I believe that when a function says that it's going to start at 5 o'clock, it should either start at 5 o'clock or something should be said. Unfortunately, we're in the something should be said category. Which is that we are running a few minutes late with our start time for some reasons that are a little bit beyond our control, but we should be ready to start fully within the next 5 or so minutes, we expect. So please bear with us and go back to doing what you were doing before I came here. Ladies and gentlemen, good afternoon. It's still afternoon. We're now going to call the session to order. Most matters having been resolved, and the rest we're leaving somewhat to faith. Maybe faith and fate. Honorable Mr. Justice Winston Anderson, Judge of the Caribbean Court of Justice, who is joining us virtually. The Honorable Marlene Malahoo Fort, Minister of Legal and Constitutional Affairs, who I believe is somewhere on campus and should be with us shortly. Mr. Wayne Robertson, Permanent Secretary in the Ministry of Legal and Constitutional Affairs. Ms. Carol Einer, Principal of the Norman Manley Law School. Dr. Christopher Malcolm, Interim Dean of the Faculty of Law. Mr. Emile Leiber, Past President of the Jamaican Bar Association. And Mr. Savion McFadden, I hope I got that pronunciation correct, who is our Mona Law Society President. Ladies and gentlemen, colleagues, and especially members of the class of 1997 of the Norman Manley Law School and the Hugh Wooding Law School. I knew that would get me some applause, so I made sure to single them out. Good afternoon to you all, and welcome. Those classes of 1997 are pleased to join with Mona Law in hosting this public reasoning about the Caribbean Court of Justice under the theme, In Search of Deeper Regional Integration as the Circle of Independence continues to close. I am your chair for this afternoon's proceedings. I'm Dave Garcia. Of course, I am of the class of 1997. I have listed the relevant dignitaries at this point, so when each speaker is ready to begin, you may choose from the list, 0, 1, all, as you desire. But I hope that we will allow persons, without them needing to say that uncomfortable, all protocols observed, to recognize that protocol has indeed been observed at the start of this session. We were at this time to have been welcomed by Mrs. Suzanne Folks-Golson, who was the interim dean of the Faculty of Law and indeed taught most of the class of 1997, with excellence, grace, and humor, I would add. However, as I believe we all or most of us know, she recently passed away, and it was only this Sunday that on this very campus we celebrated her life. In the book of Psalms, it is written, "Precious in the sight of the Lord is the death of his saints." But at this time, I would ask that we observe a brief moment of silence in memory and honor of her. Thank you. I now then ask, in her stead, in Mrs. Folks-Golson's stead, Dr. Christopher Malcolm, Interim Dean of the Faculty and a member of the class of 1997, to deliver the welcome on behalf of the Faculty of Law.
Good evening to all. both here and those who are with us in the online space. And as I follow my colleague, friend, and 1997 class member, Dave, I am accepting all that has already been done, but it is with some level of difficulty, one might say, that it is with some level of difficulty that I'm having to make this welcome at this time. We all not only expected to have Mrs. Fowlkes-Goldson here in her capacity as interim dean, but I will add that at the time the program was initially conceptualized, and when I spoke to her indicating the required involvement or the wished for involvement of Mona Law, not only was she very keen to be with us, to meet some of the persons, to see some of the persons she hasn't seen in a long time, but she readily opened the faculty and indicated that whatever needed to be done to make this event happen and to happen well should take place. And that was a spirit that we had, and it is something that today we're seeing as well, and we are all happy that we had her to have been the level of support we had as a teacher, and certainly as someone who was as supportive of the regional integration model that we're interested in, and of the continuing education and development model that we're also trying to continue at this point. Now, having said that, I do, on behalf of the principal, Professor Denzel Williams, and the entire UWI campus, Mona campus, welcome everyone, both here in person and online, to the campus and to this event. And on behalf of the Faculty of Law in particular, I welcome you to the Law Lecture Theatre too, and what it is that we're hoping today to be an exceptional program of engagement. We have with us persons, many of whom have been with this struggle for trying to close this circle of independence for a very long time. And incidentally, as I look straight across, I see A.J. Nicholson, who I know has been a very strong voice in this arena for a very long time. And there are others in the room, and certainly others in the online space, but it is an agenda which we thought as a group was impatient of debate. And in fact, we thought as a group as well that we wished to have taken out of the ambit of politics in and outer courts into a setting where we could look at it dispassionately and try to arrive at a dialogue that could be supportive of a process, albeit having to do with politics, but without some of the underpinnings that typically accompany these sorts of engagements. So again, we thank you for having made the time out. We know it's very difficult to get to Mona on any day of the week, certainly on a Thursday. And we are thankful that you're here. We have with us as well persons who have traveled, or batchmates who have traveled from all across the Caribbean and as far away as from North America and elsewhere, who are with us to celebrate this occasion with us and who will be there. We know in cyberspace there's countless others, and this is being done through UWI Media, and it's being done with our additional media partner, Business Access TV as well. So we know there's a significant footprint that is out in the online space. And we thank you, again, I say, for being here, and we welcome you warmly, expecting that we all will participate in as best a way as we can in the dialogue that is going to come out, the reason that will take place. And as we expect, persons will participate fully in the questions and answers. There may be uncomfortable questions asked, but I assure you we will do the best we can to answer them and to ensure that the dialogue continues. Thanks again for being here.
Thank you, Dr. Malcolm. We'll now invite, we're going to have a series of remarks, and we will now invite for the first of these remarks, Minister of Legal and Constitutional Affairs, the Honorable Marlene Malahoo Fort, who just barely missed being in the class of 1997, born slightly too early. Minister?
Distinguished colleagues, Mr. Moderator, I didn't barely miss the class of 96, 7, but I know you were there. Let me begin by thanking the organizers for the invitation to bring remarks at this very important public session, public reasoning about the Caribbean Court of Justice. I noted when I received the invitation that our colleague of blessed memory was listed among the participants. Permit me to express my condolence to her family and to the wider law family. It's a reminder that tomorrow is promised to none of us, and we must make use of what is before us. As Jamaica takes its journey on the road to republic in phases, the question arises as to which final court. The phased approach has the goal of abolishing the constitutional monarchy as the form of government and the Jamaicanizing of the constitutional instrument by way of having it passed by the Parliament of Jamaica and approved by the people of Jamaica as minimum goals in phase 1. But the question of the final court is a live question that demands answers. I think in this context, the tension that exists in the relationship between the judicial branch and the other branches of government is even more evident. It is a tension that stems from the differing role of each branch. And this tension is a natural tension, and in the opinion of many, it is a desirable tension. If the court's rulings were always satisfactory to the other branches, it raises a suspicion that the court was not properly fulfilling its role. And so criticisms and questions about the courts in general and court rulings in particular have a purpose of helping to guard the guardian. And why have I gone there? I've gone there because I note that the explanatory note highlights that the discussion this evening is to be an apolitical discussion, even while understanding that the Caribbean Court of Justice is born out of and dependent on political support, as is the case with every other court. I think those who are demanding, for want of a better word, accession to the appellate jurisdiction of the court are anxious to hear the arguments that could be put forward for another option. And I believe it is quite reasonable that there be a full, frank discussion on this matter. And I believe this evening's discussion will certainly aid in that process. I am here to listen, and I am here to take note. And if need be, I will ask a question or two. But I know that the search for deeper regional integration is a real search. And I think it is critical that we close the circle of independence and that we take all steps to move us forward. I am a firm believer in the people of the Caribbean, and I support Caribbean integration. And I look forward to the discussion, ladies and gentlemen.
Thank you, Minister. Our Minister has positioned the discussion within both the move to a Republican state for Jamaica and the separation of powers, and has, of course, invited us to a full and frank discussion on the issues, which we are certainly committed to doing this afternoon. Next, we will have remarks from Mr. Emil Leiber, past president of the Jamaican Bar Association.
Good evening, everyone. Thanks for having me, and I adopt all that has been said previously in totality. There is one whose initials are, I believe, AJN, who shall remain nameless, who has written extensively about the silence of the more recent silence of the Bar Association on a particular issue with initials also CCJ. I am pleased to publicly advise that the Bar Association at its recently held AGM recommitted that it will support, and as it has always done, the the joining of Jamaica with the Caribbean Court of Justice and adopting it as its final court. As a body of practicing attorneys who represents a significant portion of the number of practicing attorneys in Jamaica, it is important that the question of access to justice, which I would submit goes beyond just mere visas, but really the question of whether any average Jamaican can access justice at all its levels. It has always been said that litigation is expensive, and no one knows that better than litigators. All right? I would probably be very unlikely to sue anyone and perhaps come to an amicable resolution as quickly as possible. However, in circumstances where a suit is necessary, where it is necessary to ventilate matters in dispute before the courts, it is important that all litigants feel that they can access all tiers of our justice system. And so, on behalf of the Jamaican Bar Association, we put on record that we certainly endorse all avenues that will provide a wider access to justice for all ordinary Jamaicans, and we are certainly and firmly of the view that the CCJ is an avenue by which there can be greater access to justice. Thank you.
Thank you, Mr. Leiber. Well, I was sure I would have to adjust the mic downward after you left the mic. So I thank you for leaving it in place and for sharing with us, I think, the recommitment of the Jamaican Bar Association to Jamaica acceding to the jurisdiction of the CCJ. So it seems that the contrary argument that the minister was inviting to come forth this afternoon is not to come from the leadership of the Jamaican Bar Association. We will now hear from the president of the Mona Law Society with his remarks, Mr. Savion McFadden.
With all protocols observed, ladies and gentlemen, good evening and a warm welcome to you all in this esteemed gathering. As the president of the Mona Law Society, I am deeply honored to stand before you today in this a vital dialogue titled A Public Reasoning About the Caribbean Court of Justice under the overarching theme In Search of Deeper Regional Integration as the Circle of Independence continues to close. This occasion represents more than just a legal discourse. It embodies our shared commitment to forging a stronger, more unified Caribbean while upholding the principles of independence and self-determination that have characterized our nations. The theme, In Search of Deeper Regional Integration, is profoundly pertinent to our shared journey. Over the years, the Caribbean has grappled with the concept of integration, recognizing that a unified Caribbean amplifies our global voice and guarantees the equitable progress of our nations. We are part of a dynamic narrative that acknowledges our shared history, culture, and aspirations with the potential to transform our diversity into a wellspring of strength. The phrase, the circle of independence continues to close, though, serves as a poignant reminder that even as we celebrate our individual nations' achievements, we must acknowledge that our destinies are intricately interwoven. We must think beyond national borders and actively seek opportunities for cooperation and collaboration. In doing so, we pay homage to those who fought for independence, understanding that genuine sovereignty involves working together for the greater good. Now, before we delve into today's discussions, I am thrilled to make a special announcement. As part of my tenure as president, I have embarked on a personal passion project, Project FinRev. This project, aimed at revitalizing the financial model of our university, recently reached a significant milestone. I'm proud to share that it was presented to the heads of the university at the Colloquium for Financing Tertiary Education, and following a rigorous evaluation, Project FinRev has successfully passed Stage 1, the realization stage, and has now entered Stage 2, the actualization stage. This means that we are one step closer to the possibility of remodeling the current financial model of our university into one that's more sustainable, self-sufficient, and most importantly, more student-centric. I would like to extend my gratitude to the dedicated individuals who would have contributed to this initiative, and especially our Guild President, Ms. Omalora Wilson, who gave me the opportunity to present this initiative in this way. And I am excited about the potential transformation it holds for our institution. In conclusion, I implore each of us to embrace this opportunity for public reasoning and open discussion. Let us engage in constructive conversations that draw us closer to the deeper regional integration we aspire to achieve, while preserving the essence of our independence. Caribbean unity is not merely a matter of political significance, but it is a cultural and historical imperative. Let us endeavor to build a region where justice, unity, and prosperity can coexist harmoniously. Thank you, and I eagerly anticipate the enlightening discussions that lie ahead.
Thank you, Mr. McFadden. In his remarks, Mr. McFadden mentioned our topic within the context of both integration and independence, and reminded us, I believe, of the wider social context of our legal systems and our laws. And all three remarks have therefore, I think, teased us towards the reasoning. Jurisdictions at the crossroads, at the CCJ crossroads. For the rest of this afternoon and evening, we will proceed, as indicated in the program, to have a feature address, a keynote address by Mr. Justice Winston Anderson, and I will introduce him in a moment, and then a discussion moderated by Dr. Malcolm, focusing on the CCJ's appellate jurisdiction, and in particular, the question to which we have been alluding of countries acceding to that appellate jurisdiction. As the minister, and I believe Dr. Malcolm would have indicated, this is intended to be an apolitical discussion, while we recognize that political support is indeed required for any court in any country or series of countries to function effectively. With that, I therefore now turn to introducing Mr. Justice Winston Charles Anderson. Mr. Justice Anderson has had a distinguished career, including academia, I don't know whether to call it the corporate world or non-academic employment pursuits, and then, of course, as a jurist. He was educated at Ferncourt High School and then at St. Andrew Technical High School, because we know in Jamaica it's very important to go back to the secondary education. Also the University of the West Indies, of course, where he pursued the Bachelor of Laws degree. So that we would know that he is both intelligent and diligent, he began teaching undergraduate courses while pursuing his Master of Laws degree at the university. In 1984 to 1988, he read for the Doctor of Philosophy from Cambridge University, majoring in international and environmental law, at which time he was the Commonwealth and Chevening Scholar. He was called to the bar of England and Wales as a barrister of the Honourable Society of Lincoln's Inn in 1988. I was looking out in case somebody was going to specially clap for that. 1988 also marked his return to the Faculty of Law at this university, but in Cave Hill, where he served in various capacities, including as Deputy Dean and as head of the teaching department of law. And I believe he would have been in that latter position when the class of 1997, you know I must say this, was at Cave Hill, those of us who went through Cave Hill in the period 1992 or 1993 to 1995. I don't believe, though, that that we had the pleasure of being taught by him in either our second or third years. But on a personal note, I will say that I certainly remember benefiting personally from his guidance. And I will not trouble Mr. Justice Anderson to say whether he remembers that or not. It is quite sufficient that I do. He has held lecturing positions at other universities as well, in England and Australia. And then for non-academic pursuit, as mentioned earlier, there was a period in 2003 to 2006 when he was general counsel to the Caribbean community on secondment from UWI. On his return from secondment, he was appointed professor of law. June 15, 2010 marked a critical year for Justice Anderson and for Jamaica. He became the first Jamaican appointed as a judge of the Caribbean Court of Justice. He was also the youngest appointee to the court. And I can say at the age of 49 because it is on the website. So I'm not telling tales out of school. That very website, the CCJ website, will also provide a list of various regional and global appointments and publications. Time does not permit those to be listed in introducing him, nor, of course, those that the site did not bother to list. if were we to go down that road, we may not have enough time for the address itself. What is missing, I suppose, from his resume is that Mr. Justice Anderson has not had the pleasure of hearing an appeal from Jamaica. And it may be that our audience this afternoon would wish to hear more about that than about his accolades. And so with that, I turn over to the distinguished gentleman himself, Mr. Justice Anderson.
Thank you very much, Mr. Moderator. It is a great pleasure to be with you. And I greet you all, if I may, simply as colleagues in the law, friends, and ladies and gentlemen. I join with you in saluting the memory of our fallen comrade, Mrs. Susan Fowkes Golson, colleague of mine at the Cable campus of the University of the West Indies. I am very, very grateful to have been invited to participate in this dialogue, this conversation, this reasoning. And I want to say that I bring greetings to you from Barbados, where I am presently located. And I do so at the end of second day of a conference, which I'll speak a little bit more about later on. And that conference comes in the middle of a mission to Barbados by the Caribbean Court of Justice. And that mission involved, first of all, an itinerant sitting on Monday, in which we gave judgment in a criminal appeal. It involved the hearing of an application for leave to appeal in an extradition case. And it also heard an appeal to do with a contract between a public supplier of electricity and a consumer in Guyana. On Tuesday, we, as a court, had an intervention with the Barbados Chamber of Commerce and Industry. And that was very important because we had a chance to speak to the private sector in Barbados about rights under the CSME, created, of course, by the revised Treaty of Chamaramas. And as many of you would know who are familiar with the law in this area, we have a rather special provision in our RTC, which allows for private individuals to bring actions before the court in order to vindicate their rights, in order to defend their rights, to advance their interests, as provided for under the RTC. And that's, I think, a very signal achievement of the framers of the revised treaty. In the afternoon of Tuesday, we had an intervention with the Bar Association of Barbados. That was billed as an evening with CCJ judges. The arrangement was for us to meet about 40 or 60 Barbadian lawyers in a location. But it turned out that the location could not tolerate the degree of interest demonstrated by the members of the bar in Barbados. And therefore, we had to shift location. The organizers had to shift location. Those of you who know Barbados, the Lloyd Erskine Sandiford Conference Center at Haggard Hall, which had a capacity more consistent with the interest demonstrated by the members of the bar in Barbados. And therefore, we had something in the vicinity of 300 lawyers headed, and I don't mean to be provocative, I really don't, but headed by Dame Sandra Mason, head of state of the Republic of Barbados. On Wednesday, we started the conference to which I made reference earlier. And I have taken the liberty of this long preamble. Those of you who are still familiar with cricket, despite the fortunes of our regional team, the liberty of this long run-up, in order to situate the intervention I wish to make in a particular context. And that context is one which invites us to the realization that the Caribbean Court of Justice is not an abstract idea. The Caribbean Court of Justice is not a dream to be wished for. It is an actual reality. And it is a reality that has not been imposed upon us by anyone. It is a reality which is the product of our collective imagination. It is a reality which is the product of our collective resources. And therefore, I want to say that when we speak about the Caribbean Court of Justice, it resonates with the ideas put forth for consideration this evening. That is to say, the ideas of deeper regional integration, the ideas of the Caribbean people working, living together as one. Now, one of the advantages I have now, which I did not have in my earlier life as an academic, is that I have judicial research assistants. And they have insisted on putting together a PowerPoint presentation. I don't propose to go slide by slide because in a sense I've said almost all I wish to say. But to do justice to what they have done, I'll take you very briefly through one or two of these slides. First point, the CCJ was established in 2001, as we are almost all aware. But I wish to pause at this point to make the further point that the CCJ was established by and for the people of the Caribbean. And that in so doing, the people of the Caribbean, and the member states in particular of the Caribbean, assumed certain legal obligations. Now, there are, of course, questions as to how and when these obligations are discharged. I will not get into the weeds. I don't want to get myself into any kind of trouble. But my point is that by virtue of having signed and ratified the CCJ agreement, Jamaica, in concert with other partners in the region, has accepted certain legal obligations. And I think that that is something that ought to be borne in mind. I should say that in relation to some countries, there was the entry of a reservation in relation to their appellate jurisdiction. I do not believe that Jamaica entered any such reservation. And therefore, there is a kind of curiosity which we must investigate when we pose the question of a choice. Because from that perspective, it could be argued that the choice has been made. as I said, the question as to when and how and so on, those questions become relevant. And indeed, the issue of what is a reasonable time within which to discharge one's obligation, that also becomes relevant. But at bottom, the conceptual question has been answered, arguably. Much has happened since the court was established. The court's first decision was in 2005 in a defamation case from Barbados, the Merchant Darling case. And in 2005, there's just one case, that defamation case. But between 2005 and this year, 305 cases have been decided by the court. I'm advised that over a 5-year period, 2016 to 2021, the Judicial Committee of the Privy Council decided 20 cases from Jamaica. Whereas by contrast, in the same period, 2016 to 2021, 43 decisions were handed down by the CCJ in respect of Barbados, 28 on appeal from Belize, and 52 on appeal from Guyana. Another way of looking at this is to suggest that there has been an astronomical increase in the number of appeals coming from those countries which have acceded to the appellate jurisdiction of the CCJ in comparison to the appeals that those countries sent whilst they were sending appeals to the Judicial Committee of the Privy Council. In the case of Barbados, over 10 years since Barbados acceded to the court, there has been a 320% increase in the number of appeals going on a second tier level of appeal. So extrapolating from that, one could suggest, and this is not scientific by any means, that instead of perhaps the 20 appeals that went from Jamaica to the Privy Council, this is very unscientific, potentially 640 could have gone had Jamaica accepted the CCJ as its final court of appeal. Please don't hold me to that. It's not scientific. It's just showing you that the greater degree of access to a second tier appellate court can result in a significantly larger number of appeals. I think the court has demonstrated certain trends, and we don't have time to go through all of them. What I would say in relation to the conference I'm now engaged in at the moment is that in relation to criminal law, there have been a number of developments which are worthy of consideration. For example, the court has held that time spent on remand must be deducted from the actual sentence imposed at the end of the trial. The court has suggested that there should be a raft of remedies available where there has been unreasonable delay in the adjudication process. And these remedies can vary from a simple declaration that one's constitutional rights have been infringed to an apology by the relevant state agency to a reduction in the sentence imposed to compensation. The court has made many pronouncements in the area of, for example, domestic violence. And based on legislation in Barbados, the court has made it clear that a restraining order may be appropriate in all kinds of domestic arrangements with which we are very familiar in living, and not just, of course, the nuclear family situation. The CCJ, as our chairman, I think, hinted at, is really composed of Caribbean judges. And I think that's important. I'm honored and gratified to sit on the bench with very learned colleagues. These are Jamaican, but these are Caribbean nationals. And I want to say that outside of the kind of judicial developments I've just hinted at in relation to criminal law, of course, we have done lots of things in relation to constitutional law, in relation to international law, and so on. But the court has also embarked on efforts to ensure that we recognize the contribution that has been made by persons who have gone on before us in the legal field. And therefore, the CCJ Academy for Law, which I have the honor to lead, has instituted the Eminent Caribbean Jury Series. And this year, we honor legendary Caribbean legal practitioners, 48 from around the region, including from Jamaica, Norman Manley, David Core, Lloyd Barnett, Frank Phipps, Ian Ramsey, Jack Smith, Dennis Morrison, Hilary Phillips, Vivian Blake, and the list goes on. And of course, the Academy also puts on conferences from time to time. And that's the reason I am currently in Barbados attending the 7th biannual conference, which looks at reforming our criminal justice system. And the objective is to achieve a modern criminal justice system. We have a raft of speakers. What I think is perhaps of interest to your audience, Mr. Moderator, is that the speakers include many personalities which are known to you and your audience. So today, for example, we heard a very impassioned, very spellbinding address by the Chief Justice of Jamaica, Chief Justice Sykes. We have heard from Madam Director of Public Prosecution, Ms. Paula Llewellyn. We have heard from the Deputy Commissioner of Police, Mr. Daly. And tomorrow, I just checked to make sure that his IT requirements have been met. We hear from the Minister of Justice of Jamaica, Mr. Delroy Chuck. And we're talking about many things of concern and interest to the Caribbean people. We're talking about pretrial detention, the fact that we have so many of our young people, especially young men, who are held in detention for inordinately long periods of time. We're talking about plea bargaining. We're talking about anti-gang legislation. We're talking about judge-alone trials. We're talking about victims' rights, because very often we forget the fact that there are people who are suffering, who are in fear in their homes, at their workplaces, in the public, because of this scourge of crime that we have in our region. And we as judges are as concerned as anybody else. We do not have the luxury, with the greatest of respect, of living 5,000 miles away across the Atlantic. We live here. And there are lots of stories of judges' homes being burglarized, the judges coming down from upstairs to downstairs and finding unwelcome intruders, and having to resort to primitive measures to regain the sanctity of the residents. One of the interesting things too, and this came out very clearly, presentation from Trinidadian Justice of Appeal, is that the detection rate, conviction rate is so very low that we miss the victim sometimes. So if you have a conviction rate of 14%, then, you know, over 80% of the victims of crime do not have an appearance in the justice system. And we lose them. But they don't lose their pain. And they don't lose the fact that they've had to come face to face with real challenges. And they lose a breadwinner. There's, you know, just displacement in their family situations and so on. We are talking about sentencing. What is an appropriate sentence? I think Minister Chuck will have some words to say about that tomorrow. Mental health and crime. This evening we had a very spirited discussion about whether the hearsay rule ought to be abolished. And something that, if you give me a point of personal privilege, I am very proud of, is the fact that we have had a regional town hall, something I've been trying to get done for the longest while, where persons from around the region were able to call in their concerns, call in their suggested solutions to this particular issue, in this case, the issue of crime. I think the idea of the town hall is very important because it enables us to define a space where the Caribbean public can come together and converse together, can reason together, and can express their points of view. And we can't build a society, we can't have integration unless we have a public square. And thank God, if you forgive the expression, those who are not believers, we do have in this modern day and age the facility to create a digital town hall, public square, and we did that very successfully during the course of the conference. There are other things that we are engaged in. I don't want to take up too much time, sir. So what I'll just end by saying is that I think that the court and its affiliates continue to endeavor to make a useful contribution to Caribbean jurisprudence, both through the judicial process and the non-judicial process. And we hope sincerely that this contribution is worthy of your consideration and discussion. Thank you, sir.
Thank you, Mr. Justice Anderson. We have, I think, in that address, had a very interesting discussion occur in relation to the experience in Barbados and the manner in which their transition occurred, including the interventions. I found that to be quite interesting, as well as the statistics that have been shared with us with respect to the number of cases decided by the court in the period since its inception. I found it quite striking. I don't know if you did as well. The significant number of cases that are being heard by the court from jurisdictions smaller than Jamaica as compared to the number of cases that have been heard in that 5-year period surveyed by the Judicial Committee of the Privy Council coming from Jamaica. I think that was quite a striking number, and we can think about what the reasons for that type of difference might be. And clearly there were vast areas of law covered by the court in its appellate jurisdiction. No surprise, of course, given the number of appeals that were heard. So, Mr. Justice Anderson, we do thank you very much for the data that you have shared with us and for the insights that you have shared with them, even as you very judiciously steered clear of the thorny aspects of the topic that we're hoping to get into in the moderated session that is to follow at this point. And so with that, I ask our panel discussion moderator, Dr. Christopher Malcolm, and our discussants to step forward, if you may, and to take, I assume that the seats here are for this purpose. and so if I can ask that you step forward and take your seats, and then I will ask Dr. Malcolm can introduce the discussants and have our discussion get underway.
Yes, good evening again, and thanks, Dave, for having led us up to this point, and certainly to Justice Anderson for having set the stage for us for this reasoning session, which could be uncomfortable at some points, maybe, but we're hoping in any event for it to be fulsome in how we deal with it. Now, at this point, there are 4 panelists that I have the pleasure of introducing them. And I'll start in the order they appear, my right, going around in that semicircle that we have it. Immediately to my right is Ms. Magali Marin Young, class of 97 alum. She is a former Attorney General of Belize and senior counsel there as well. And she has had a very distinguished career to date, including several appearances in the Caribbean Court of Justice, where she has distinguished herself. And very recently, we saw a very significant judgment coming out of Belize, where there was a lot of very groundbreaking matter involving the rights of a father, it would have been, in circumstances where he was being required ordinarily, by reference to their legislation, to maintain children after separation that were not his. And the court, with her having argued for him, was able to make a clear determination that that position was unconstitutional and discriminatory. And I suppose the men may be happy in terms of where that decision was, but that is something that we saw coming out among the many other matters that she has been involved in. And Magali will, of course, take us through her own position by reference to involving, of course, and what you will note, I mentioned at this point, is that we have tried as much as is possible as well to ensure that this panel is experiential as much as it is about persons simply speaking about what they have read about, thought about, and so on. It's experiential as well. Now, to her right is B. St. Michael Hilton. And on this occasion, he has told us we should say Mr., nothing else, even though there's another reason we could say otherwise. But he is not a member of the class of 97, but he has had the privilege of teaching many of us and having worked with many of us in one capacity or another. And he is a continuing mentor for many of us from that class as well. And he too has had experience in the Caribbean Court of Justice, including having sat on the Regional Judicial and Legal Services Commission, which deals with the appointment of judges in that court. And he has practiced across the region, and his notoriety is well established in his own capacity as a commercial litigation lawyer and in other areas as well. For his sins, he has also been the Solicitor General of Jamaica. For his sins, he will, in due course, sit in another capacity, which he might, if he so desires, speak about, probably not today. But what we do know is that he brings with him a wealth of experience and a wealth of understanding of the region. He's a UWI graduate, of course, and he has a regional footprint which brings to bear, which he will bring to bear, and which will, of course, inform the perspectives that he has. We like the youth, and with us is young Shakira Douglas, not yet admitted to practice, but she is a graduate of the University of the West Indies and also of the Norman Manley Law School, and she is as well. She was a, and you'll see it there, a committed, class of 97, called and committed scholar. We, in fact, when we had our first get-together, I might call it, in Barbados, she was one of 2 persons selected by the group as one of our scholars, she being from Norman Manley, another from the Hugh Wooding Law School. So she will bring her voice, not with the experiential value of the others yet, but with the voice that we expect to help us as we emerge and move forward. So it's an evolutionary experience that we will be getting through her. And that is part of what we're looking forward to in a very excited way. Then we have, at the very end, and I don't know why his head is down, Larry Smith, King's Counsel, and he is a class of 97 alum as well. And his base, and I call it that, is Barbados. But he too is a regional man with footprint all over the place. And he has been involved in a number of matters that have also gone to the Caribbean Court of Justice, and a lot of them very groundbreaking in the matters that have gone there and the matters that he has been involved in litigating in the Barbados courts. He too brings his own experience, not just with a view to the legal elements, but the one thing you will know, and I know it pains him, and I mention it all the time, Larry used to play cricket at a very high level. and I know that whenever the West Indies are down, there's nobody closer to tears than Larry because of his own personal involvement as a cricketer who played for Barbados at a particular level. So it's not at a low level at all that he played cricket. So that is who we have here. So he's bringing his love for cricket and the experiences coming out of that, which he has taken to the regional space of the practice of law. And his contribution, of course, today is going to be looking at what he has seen from his own experience in the CCJ and how he thinks it could help us as we're navigating in Jamaica our next steps on this path. So this is our panel for today. And what we're going to do is that we will have each person give a short indication of, an overarching view of where they stand. It is going to be a moderated discussion where we're having questions, and we will in fact have a period of questions and answers at the end, which will include persons in the online space as well. But I'll start with Magali as to what her initial views are relating to the topic and where she proposes to take us today.
Good evening, everyone, and greetings from the Jewel, Belize. It is indeed an honor to be invited to be part of this discussion, which I think is very healthy. In Belize, the Bar Association had wished it had more consultations, and I am happy to see that Jamaica is engaged in this open discussion before you consider taking that major step of having the CCJ become your apex court. From Belize's perspective, we joined the court. We took the decision in 2009, and we joined the court on the 1st of June 2010. And I don't think there is any Belizean to date that has any regrets about us joining the CCJ. I can only speak of pluses tonight because that's been our experience. I went over some statistics recently, and let me just tell you what was the impetus for Belize to join. It was simply a sense of national pride and dignity. Since the 2009, early 2000, Lord Phillips, who was the then president of the UK Supreme Court, had been signaling that the Commonwealth countries need to establish their own apex courts. And he had basically, in a very patronizing speech, I thought, said that, you know, the Privy Council is providing this service free of cost to the Commonwealth, and their judges are, you know, spending a lot of time hearing cases from the Commonwealth, diverting precious judicial time away from their own legal reforms and modernization. So for Belize, it was a sense of national pride and dignity that we took the decision to join the CCJ. And I can only share with you, it's all been positive. For one, when we look at the statistics, we used to have perhaps one matter going to the Privy Council per annum. And on the criminal side, it was only those cases where the person was sentenced to death that made its way to the Privy Council. Why? Because persons who are facing the death penalty could count on pro bono services of barristers in the UK. Otherwise, it was totally unreachable as a court because of the prohibitive costs of instructing barristers in the UK. On the civil side, it was only the well-heeled Belizeans and large corporations who could afford to appeal their matters to the Privy Council who were able to do so. Today, I can tell you, since joining the CCJ, there has been an uptick of criminal matters as well as civil matters. And it's not only those matters facing the death penalty. We have rape cases going to the CCJ. On the civil side, we have a wide variety of matters reaching the CCJ, from public law to contract law to tort reaching the CCJ. So the court has certainly been far more accessible. Persons like myself and Larry have appeared before that court. We would not have had that opportunity to appear before the Privy Council as we're able, as practitioners in the region, to appear before that court. So from the Belize perspective, I think I can share with you in Jamaica that we certainly have nothing but positive things to say. It's a young court. And I think that our decisions, and if you read the decisions coming out of the court, I think a lot more attention, a lot more rigor is placed in the analysis of those cases. Some of us who have had to read the decisions coming out of the Privy Council will note that the Privy Council has paid short shrift to some important issues that we face. Whereas I think the CCJ, we have seen depth and rigor in the analysis, the decisions coming out of that court. So it's a young court, yes, there will always be room for improvement, but I think that accessibility is the most important because it makes no sense for you to have a final court with the best legal minds in the United Kingdom if that court is unreachable because of the prohibitive costs. So from Belize's perspective, accessibility has been the greatest plus. But there's another important point that I think I need to mention tonight. When you argue a matter before an apex court, it is not only precedents, court precedents that you cite, but you also, the argument becomes deeper. It becomes grounded in policy. And this is where we, as a region, are able to argue policy before an apex court, because recall, an apex court can reverse decisions that have, age-old decisions. But at that level, you can argue regional policy. You can argue policy that those same judges are able to relate to as a Caribbean people, having lived in our jurisdiction. So I just want to share with you that there are many plus sides from the Belize perspective. I am sure there's room for improvement, but accessibility has been the greatest gift in joining that court.
Yes. Thanks, Magali. Thanks, Magali. Now, we're going to hear some initial opening thoughts from Mike, and then we will. Mike?
Thanks, Chris. Good afternoon, colleagues, friends. Uh, my mic not on?
Testing.
Thanks. Okay. Let me start by congratulating the class of 1997. Many of us, many graduating classes, have had reunions and celebrations at various levels. But what this class has done, I think, has put us all to shame. And especially including something as important and valuable as today's session. Those who know me know that I have long and unapologetically fully supported Jamaica's accession to the Caribbean Court of Justice appellate jurisdiction. And no. For a lot of the reasons that Magali just stated and others have stated, on this question of accessibility and the approach of the law lords, let me use my time to share some information that I suspect many may not know. And this deals with appeals as of right to the Privy Council. And I think, as we all know, our constitutions all have provisions for appeals as of right and appeals with leave. And the appeals as of right are, whether it is to the CCJ or to the Privy Council, are in our constitutions in particular situations. This year, earlier this year, the Privy Council adopted a new procedure for dealing with appeals as of right. That procedure involves a single judge reviewing all such appeals to determine whether they have merit. If the single judge considers that the appeal has merit, it is referred to a panel to go to hearing in the usual way, except that the appeal may be heard by 3 judges or 5 judges. But if the single judge concludes that the appeal is wholly devoid of merit, the single judge will refer it to a 3-member panel who will determine whether to dispose of the appeal without a hearing. These are appeals as of right. This panel will invite the appellant to send in written submissions as to why it ought not to be dismissed without a hearing, and will then proceed. Now, statistics are not being published, so one cannot tell exactly how many have been dealt with in this way, but I'm aware of at least 1 appeal from Anguilla, appeal as of right, that was dismissed without a hearing. Now, there are a number of things that have happened that suggest to me that the law lords are spending much less time and giving much less attention to Privy Council appeals. And you know that they sit in both the Supreme Court and in the Privy Council. I'll give you a couple more statistics. This court term, the Privy Council is listed to hear 3 appeals from throughout the Commonwealth, 3 appeals. This term last year, they heard 22 appeals. In May of last year, May of 2022, I appeared in an appeal before the Privy Council. They reserved judgment and gave judgment in December. But it was a preliminary judgment because they invited the parties to submit draft orders. The parties submitted draft orders in February, and now, 8 months later, we're still awaiting a decision. This is after multiple reminders from both sides. Give you another example. There's an application for leave, an application for special leave by a litigant in the Bahamas. So the Bahamian Court of Appeal heard an appeal in July, and an application for special leave was made then. And those of you who practice in that court would know that historically, those applications were determined in weeks. It's now October, no decision. All those developments tell me that perhaps following upon the matter that Magali mentioned, the comments that were made some years ago, they're now implementing them. And I think that the discussion we're going to have today should follow against that background, keeping those developments in mind. Let me make one other observation. You made the comment about the judgments and the difference between the judgments of the Privy Council and the CCJ. I need to keep in mind, that's not a mistake, that's not an error. The Privy Council, certainly in most of our jurisdictions, Trinidad is different, certainly in Jamaica, are not delivering judgments. They're delivering advice to know His Majesty. And it is a matter of policy that you don't do dissenting judgments and you don't do unnecessary incursions into setting precedent and developing the law. Say for constitutional cases, when they do that, generally speaking, they avoid doing what apex courts should do, which is develop the law. They're advising Her Majesty or His Majesty on the matter before them. There's a reason why the CCJ's judgments go into depth in a way that the Privy Council does not. It's not accident. In our discussion, our consideration, those are all factors that I think should be brought to bear, and we should also consider. And finally, there are so many reasons to accede to the appellate jurisdiction, but if I'm asked to choose one, it would be the one that was emphasized here: access. Access to justice, access to a final appellate court is something that the vast majority, speaking of Jamaica, of Jamaican litigants, do not have access to a final appellate court. And that alone, in my view, is a compelling reason to make the transition. Thank you.
Shakira.
Thank you, Dr. Malcolm. Good evening, everyone. I would first like to thank the class of '97 for inviting me to sit on this panel. I am humbled by the invitation because I am not only here in the capacity of as a discussant, but I'm also here to learn from the legal stalwarts that I'm joined by. I would also like to congratulate you because in my interfacing with preparing for this discussion, I realized that this is not a new conversation. It has been happening from as far back as 1901. And in coming to that realization, I also interfaced with the reality that, yes, we're a country that believes in our sovereignty, that believes in our national pride, that would want to embrace what it truly means to be an independent country, but in some ways we're still compromising what that sovereignty means by not acceding to the appellate jurisdiction of the Caribbean Court of Justice. And I think that segues into the personal view that I hold. Having done my legal education at the University of the West Indies and moving on to the Norman Manley Law School, we would have had to interface with the Caribbean Court of Justice as a topic or just the infrastructure several times. And I would have realized that when you juxtapose that against the reality of what the Privy Council is, you realize that we are, in a number of ways, doing ourselves a disservice by continuing to entertain the jurisdiction of that court. And I will borrow the words of the panelists before me by saying that one of the greatest flagship points for why we should accede to the jurisdiction of the CCJ is the access, because it cannot be that you have a country that has a legal or legislative arm that is touting justice and the access to justice for its citizens, but yet when it gets to the apex level, we're unable to afford that to our clients or litigants on a whole. And I will add, in terms of, I guess, observing the discussion around it, I have seen the concerns as it relates to why it is that the CCJ might not be a good fit. But when it is that you zero in on what those concerns are, and I would not delve into them at this juncture, I believe it's going to come up in the reasoning. When you zero in on those concerns and you do your research on those concerns, you would realize that a lot of them, for want of a better phrasing, do not hold a lot of water. Because when you balance the concerns that we now have with the Privy Council versus those that we have with CCJ, we're not saying that it would be a perfect apex court for us to have, but it definitely would inure to our greater benefit than continuing to stay within the jurisdiction of the CCJ. I will close by saying that, or close the opening remarks by saying, I am all for closing this circle of independence by us shifting, and I hope that this timely conversation and reasoning that the class of 97 has allowed us to put on this evening will signal that change is indeed on the horizon. I believe in the spirit of the country and the Caribbean by extension, we are all eager. We are all eager to see Jamaica really stand on what we truly want to embrace as national pride and sovereignty. So I'm hopeful that this indeed does signal that change is coming soon. Thank you.
Larry.
Good evening, everyone. Good evening, everyone. It's a pleasure for me to be here as a proud member of the class of 1997. I must first start by correcting something that Chris said. Though I wish it were true, I did not represent Barbados in cricket. I did go to under 16 and under 19 trials, but was not good enough to make it. No. Thank you. No. I can echo the sentiments of what Magali has said. Having appeared at the Caribbean Court of Justice, firstly in 2010, when I did the Frank Gibson case, which some have said has been a fairly seminal case in constitutional law in the region in the last 20 years. And had my country not had that court as an apex court, not only would I have not appeared, but the legal reasoning coming out of that case would not have been available to us in the region. Not because I did anything spectacular, but the court was available. I do not quite understand why a country like Jamaica, which for me has been a leader in the region in arts and culture and helping us embrace what is specifically ours, finds it difficult to make that shift. For me, you have reggae, you have dance hall, you have all these beautiful things. But then you say to yourself that, you know, our brothers and sisters in the region are not good enough to stand in judgment as an appellate court, an apex appellate court. That boggles the mind. It's incongruent for me, knowing my Jamaican friends who I went to school with and their sense of national pride in their country, for Jamaica to not accede to the CCJ in this appellate jurisdiction. It is something I cannot fathom. But Magali said something earlier, and it is clearly that this young scholar here read the article from Sir David Simmons in Nova Law Review, because I noticed when she said this from long ago as 1901 that we were speaking about a regional appellate court. But Lord Hoffman in 2003 said on a visit to Trinidad and Tobago, it is extraordinary. It is an extraordinary fact that for nearly 9 years, I have been a member of the final court of appeal for an independent republic of Trinidad and Tobago, a confident democracy with its own culture and national values, and this is the first time I have set foot upon the islands. No one unaware of the historic links between the islands and the United Kingdom would believe it possible. How much longer do they have to tell us what they're telling us before we do something about it? Where is our sense of pride? You know, Mike has spoken about it, about what this Privy Council is doing. Do we need a further push? I think we're like beating a dead horse. When I speak to my colleagues, my peers, they're all for it, and I can't understand why there's no push. I know the Barbadian experience was easy. There was no political divide on the issue. In preparing for this panel discussion, I sat with Sir David Simmons, who was the Attorney General at the time when we acceded to the jurisdiction of the CCJ and was a major player in the establishment of the Caribbean Court of Justice. And from as early as 1990, there was an intergovernmental meeting at which the then Prime Minister, Erskine Sandiford, as he then was later to become Sir Lloyd, had agreed in principle with the establishment of a regional court, such that when Sir David assumed office as Attorney General in 1994, seeing the file, contacted Edwin Carrington and said, okay, this is something that we should push. Now, it boggles the mind that Jamaica and the other members of the CARICOM community would borrow money to support the trust fund, which establishes the court and keeps it functioning, and then not enjoy the benefits in full measure of what the court offers. That is something again, I don't get that, and I think Jamaican people should be rightly aggrieved that their taxpayers' money has been spent in this way, and then the access to justice they cannot have. And that's a critical thing I think I would like us to get from this is the access to justice. Being able to argue matters which otherwise may not have gone. I feel fairly certain that had the CCJ not been the apex court, the Frank Gibson case would never see beyond the Court of Appeal of Barbados. I just feel that very strongly. I certainly would not have appeared at the Privy Council. And that's what Magali said. I would not have had that exposure, that experience. And the court is a sound court. I just don't understand. What is it about the brains or the minds of our judges at the apex court, at the Caribbean Court of Justice, that we feel is inferior to the minds of people sitting in London? Are there any smarter? I don't get it. Our lawyers have appeared at the Privy Council and argued cases for, I guess, centuries. They've studied in England beforehand and top classes. So there's no issue about our intellectual capacity to deliver justice for our region. I was speaking to a classmate who had just the other day who said, well, she was 2 years ahead of me, said that, you know, the whole issue of corruption and so on. So even if that were an argument, which I think it is a fallacious argument, quite frankly, so only us are corrupt? So the other people, they are not corrupt? It's an argument that doesn't make sense. And having appeared at the Caribbean Court of Justice, I feel confident in our judges. The level of scholarship, the level of preparedness, the technology that is available. You know, I argued a fairly important case, and when I left number 134 Henry Street, I had a decision. And an order prepared, typed, signed, and stamped by the court when I left. What is it that we are afraid of? What is really the issue? So I will just, you know, encourage us. And I look at the right excellent Earl Walton Barrow, who is a regionalist, one of the architects of CARICOM, along with Michael Manley, Eric Williams, and Forbes Burnham, the original Treaty of Chaguaramas. And he said in a speech, when we were approaching independence, we will not be found loitering on the steps of the colonial master after closing time. Thank you.
Thanks. And I thank the panelists for the discussants rather, for their intervention. But Larry ended someplace asking the question, why has Jamaica continued to be in the position of ambivalence, if that's the word we want to use? And so for that reason, I'm going to go to you, Mike, because you are perhaps you've been around on the panel long enough to be able to speak to that. But, but the question, Mike, is, and we recently, let me contextualize it by saying we recently had some public opinion polls which suggested, however well, it was a scientific poll, that suggested that 59% of Jamaicans are favoring accession to the CCJ, and only 23% were favoring continuation with the Privy Council. And I think it was 18%, that adds up a further 18. 18 it would be. That said they were not sure. I'm not sure what the not sure means, but having heard that, The question is, as a matter of national sentiment, from your own experience, what do you think is at the root of, let me stick with the 23% for the minute. Why do you think, with national sentiment and so on in mind, that there's a holding out 23% at this time?
Okay, so this debate, of course, has been going on in Jamaica for a long time. We've moved from a place where most people knew very little about the CCJ Privy Council issue and cared less. People, it was unfortunately seen as a JLP, PNP issue by many people, and their support or lack of support would depend on what side they fell on. What has happened, I think, to change the conversation is the voices that have been added. The voices like the Bar Association and churches and civil society and persons. And I need to give a lot of credit to Minister. And she chairs a committee that is looking at reform to the Constitution. And what Minister's committee has been doing is, and I see other members of the committee here, is going around the island and talking about constitutional reform. And they're focusing on the Republican, change the Republic issue. But it is necessarily driving the debate about the CCJ. There's therefore been greater awareness of the issue. And I think an increasing feeling of there's somewhat of an anomaly of moving to a republic and keeping the CCJ, keeping the Privy Council. So in terms of your poll numbers, those numbers were surprising to many of us, given where we're coming from. I think that's what has been driving it. Okay, now to answer your direct question. I don't like to be making arguments that other people have made, because I may not do them justice. But the people who are ambivalent or hesitant have put forward various reasons. And none of them, Larry, say it's because of lack of intellect or lack of ability of our judges. I think the reasons are offered are, one, the Privy Council is distant, and that's a good thing, that they're not subject to influence, and we have a suspicion of ourselves. We suspect that our politicians, our lawyers, our judges, everybody is somehow subject to taint and corruption. And I talk to people, especially lawyers, and there are many members of our profession who are not supportive of the move. And we need to put that on the table, it's a fact. And I'm surprised that today, still many of them have no idea how the judges of the CCJ are chosen. They have no idea of the level of insulation and total absence of political influence or interference in that selection process. I do. So there's a hesitation for that reason. People talk about they won't say the intellectual ability, but they'll say the history. And the Privy Council has been there for 400 years. Former Prime Minister Siago had an argument against the Privy Council, against moving from the Privy Council, that you may not have agreed with it, but it was rational. He said, and we're talking about 20 years ago, 15 years ago, he said, this is a new court, the CCJ. We need to watch and see how it operates. And I think he may have said 5 to 10 years. As I say, you can argue, you may not agree with it, but it was a rational position. That's 15 years ago. And nothing has happened that I can see done or omitted to be done by the CCJ that could justify that sentiment from still being maintained. But it is. So you will hear that kind of comment. And I'll give you one last one. People say commercial clients won't want it. That commercial clients find comfort in the Privy Council that they won't find in the CCJ. I practice in the area of commercial litigation, I have never heard a client say that. That's my experience, personally. But it is one of the reasons that people, especially lawyers, and I say lawyers really because that's who I talk to mostly on this topic. So I think those are the reasons I have heard people give in Jamaica for not supporting acceding to the Privy Council.
There's a quick follow-up question I want, but before I get there, let me just get a quick response from both Larry and Magali on this point. Mike just mentioned an argument that commercial clients don't want it. What has been the experience from Belize, Magali, and Larry? After Magali, you'll tell me the Barbados experience on that point.
Well, before coming here, I conferred with a colleague who represents a large UK investor in Belize. And I said, you know, have you sensed any hesitancy from that group of investors in relation to appealing to the CCJ? And his response was absolutely not. In fact, I think that investor has the most appeals before the CCJ. So for commercial clients, in the Belize context, that has not been our experience. Lack of confidence of the legal minds and jurisprudence on commercial law coming from the CCJ.
Larry, what is your...
This is not the area in which I practice. My cursory knowledge is that there's no issue. Because again, the access, businessmen and businesswomen companies would spend less arguing a matter at the CCJ and getting determination in fairly short order and going to the Privy Council. And nothing is more important for the businessman or businesswoman than a quick determination of their matters because money is involved. So the argument that in the commercial realm it's an issue, to me doesn't hold water. And certainly at home, the beautiful thing about the decision that was made is that the decision was made.
Let me ask you a follow-up there, Larry. I know it's not your area of primary practice, but I know as well that you have tentacles that extend to Guyana. And we know that Guyana is a booming area now for investment. Guyana is in the CCJ. Have you heard from any of your connections in Guyana that there is hesitance and any indication that investors are backing away on account of their apex court being the CCJ?
No, I have not. I think Justice Anderson just heard an appeal, the court in Barbados out of Guyana. I think it was in 1980 that Guyana abolished the Appeals to the Privy Council and had their own court of appeal as their final court. And once the CCJ was inaugurated, they had no hesitation in moving to the Caribbean Court of Justice. So in many ways, Guyana has been leading that charge in the regional jurisprudence and in embracing the regional court. So I haven't heard any of my colleagues there saying they have any issue with the CCJ in commercial matters, to be quite frank with you.
Okay, Mike, I promised I'd get back to you. And Shakira, you're not forgotten. I'll get to you in a few, yes? But Mike, I'll get back to you for one thing, because one of the contentions you hear, and it's an elephant in the room almost, is that it appears a growing sentiment of persons having discontent with our local courts across the region, not just in Jamaica, elsewhere as well. How much do you sense that persons are using the fact of their discontent with local courts to fry the CCJ?
Oh, that's a good point. And that is a point, too, that I omitted mentioning, that people say, look at the delays in the local courts, look at the problems with whatever. And it's not a leading reason, but it is a reason being given by some persons. And my answer is always the same. It's not the same court. It's not the same resources. It's not the same circumstances. You can't judge the CCJ by our Court of Appeal in the same way you can't judge our Court of Appeal by our parish courts. They have different resources and they have different circumstances. And the CCJ has advantages that the local, i.e. Lower courts in our region don't have in terms of range of the pool from which judges are drawn, the resources available to it, the technology that they use, a variety of factors that you really should not judge the CCJ's circumstances by the problems you see in the local courts. And as I keep coming back to, it's not a new court. I mean, it's not 400 years old, but there's been more than enough time for you to judge these things. And Justice Anderson made a comment that is no longer a dream. It's long past that stage. So that's my answer to that concern.
Shakira, you're the young mind in the room, and you're the future of the practice in many ways. We're here, we're seeing you coming through the door. What you, no doubt, and perhaps in preparation for this, would have engaged with some of your peers. What are you hearing from them, and what anxiety, if any, do they have about accession to the appellate jurisdiction of the court?
I have indeed been conversing with some of my colleagues on the topic, and the reaction has been mixed. I believe, though, that one of the main things that they've highlighted is that they are eager to see Jamaica move in the direction of acceding to the CCJ as our apex court. And one of the major reasons that they've highlighted is the efficiency and the cost effectiveness of having them as our final court. I mean, Mr. Smith would have mentioned that a long time ago, Jamaica... Oh, he said Larry. Larry would have mentioned that a long time ago, Jamaica would have been one of the contributors to the CCJ's trust fund. And I think that we are doing ourselves a disservice by having spent all of that money. I think it was upwards of some 20 odd million. But I think we're doing ourselves a disservice by having contributed so much to a court that we are not using in its original jurisdiction. And they are eager to see us now take the step to move into that direction. Secondly, one of the other reasons that they have highlighted is it makes no sense that to get justice in a matter, you have to obtain a visa. And we know that visas are not as of right, and you have to apply for them and obtain them, and there's a chance you might not get them. So it makes no sense that to seek justice in your matter, you then have to apply for a visa, not only for yourself as the litigant, but also the persons who would be representing you and their team, however large that team might be. So I think that cost effectiveness of the entire regime of having a court in our region is what bears in the CCJ's benefit. Another reason that they've highlighted is the fact, and I think this comment, statement, worry or concern has been repeated several times, is that the Privy Council, for all intents and purposes, and just how it is framed, is out of step with the realities of what takes place in the Caribbean. And whilst you are not making judgments as judges based on the feelings or the realities or culture of a particular set of people, it does help or play a role in the kind of judgment and the analysis that is produced from that court. I mean, as a student of the law, and not yet called to the bar, one of the things that I've seen is very important for the continuation of the legal practice is the development of our jurisprudence. And whilst the law is not running a race with the changing times, it must, in order for it to be sustained, move and evolve with how society and culture is evolving. Now, if you have a court that is out of step with the realities of what is happening in our country and producing judgments for that country, you are going to find yourselves in a gap where the laws and the culture or the legal jurisprudence of that country is not moving forward. So that is one of the things that they've highlighted. And finally, I'll touch on the fact that we're in a space, not only as Jamaicans, but as the Caribbean, where we're seeking many avenues to really stand on what it means to be independent. And I believe that one of the reasons that is most important for why my colleagues are eager to see us take this step is you're having a chance to embrace what CARICOM would have intended, what the CCJ would have intended in its formation to have legal certainty that is truly Caribbean. And I say that to say a lot of the judgments that have recently come out of the CCJ, not just on Jamaican matters, but Caribbean matters, have advanced how we look at free movement, for example, how we look at economic integration, how we look at trade. And if we can continue having legal judgments come out of a court that we have as our final appellate court, then I think not only are we advancing legal jurisprudence, but we are holistically developing ourselves as a country and Caribbean.
Sir.
I was going to close by adding that one of the major, I guess, reservations that my colleagues are having, and it's not really a reservation for me because I don't see it as being a stumbling block, is the trust in the system. But what we have heard here and what is out there as a fact is that the court is not a new court. It hasn't been around for 400 years, but it is not a new court. And if it is that you are having difficulty with accepting that you can insulate the court, or the court is already insulated from undue influence, or you can insulate it from corruption, look at the judgments that have been coming out of the CCJ to date. And if it is, I dare say, if it is that were a very real concern, we would have been hearing about it in the feedback for those judgments from the times that they would have been coming out. So I think, yes, that is a reservation of my colleagues, but again, with deeper research that can be explained.
It's, for me though, there's still an elephant in the room related to that. And I hear us saying, and Mike, I heard you, that the court is a different court from the local courts. But at the end of the day, we still exist in a region which is small. There are close connections in many of our jurisdictions. On Montserrat, on a good day, you have 5,000 at maximum people there, for example. Use that as an example. And we could go down the list of the number of persons that you have. So invariably, you have close connections at every level, right? And it is a question really for everybody in a sense. But I'm going to get to where I'm going. Because one of the things, if we understand stakeholder analysis, for example, yes? We understand that influence tends to override, I was about to use Trump, but that's a different word. But it tends to override importance, right? And that's something that we understand. And in fact, the typical way of understanding that is that importance only becomes critical where it coincides with influence. There's that level of analysis that takes you there. And the question, we hear it enough. Yesterday I had a very extensive conversation, also in preparation for this, with a very senior lawyer. And the question was along the line of the agendarization of our courts, deliberately used, and the extent to which influence has informed how our courts function, and whether that is a genuine reservation that one could have about the CCJ being a court of the region in the context of a small region. And I'm going to add something else before you all jump in on it. In this context, and this is the elephant in the room, we have from time to time either heard ourselves or observed ourselves instances where we see judgments, and we are left to consider whether it was a judgment by reference to the facts, the law, and the circumstances, or instead a judgment by reference to influence. Implicit bias is what we sometimes call it. And the question is, are we satisfied that the Caribbean Court of Justice, and by extension, our local courts, are functioning in a way which understands this, and where the influence is being minimized in favor of importance and in favor of judicial correctness? Starting with you, Magali.
You know, I can only share in terms of Belize's experience. That has been a concern, but I want to think and that when our Caribbean brothers and sisters sit as jurists, there is a certain intellectual pride in, being able to compartmentalize friendships versus the facts and the law. And when writing decisions and deliberating, I want to think that, they take great pride in their decision being legally sound. So it is a concern for Belizeans that maybe there are influences. I think that in the past, that was significantly an issue. I think several of our high court judges happen to have gone to law school with a former prime minister. And so, for Belizeans, the issue was, this is rather too much coincidence to be an affront to common sense. But at the end of the day, I think, in terms of, that apex court, I do believe, and it's been my experience, that there's intellectual pride in our jurists sitting on that court and wanting to do right by our society. So at that level, I don't have reason to suspect that, in fact, influence may play any major role. The decisions coming out from our, in relation to Belize, have been good decisions seeking to correct weaknesses in our constitutional democracies in terms of corruption, in terms of executive decision. So I think the experience coming out is the decisions are sound, and that they recognize that we live in small societies. They recognize that we do have challenges as small societies with our democratic institutions. And the decisions have been to correct the abuse of executive power, the separation of power. We've had some very interesting decisions on policy, decisions taken by the legislature, but which were considered contrary to public policy. And we had the Caribbean Court of Justice make a judicial pronouncement on that. So I think they, more than anybody, recognize that that is a potential weakness. And I think that the jurisprudence coming out of them reflects that they want to do good by our small societies, and they too recognize our weaknesses. So that's been the Belizean experience.
Mike, on that, what if anything, would you come?
I won't even go to the CCJ. Let me just talk about our local courts. I don't think that there's a major issue or concern influence. The biggest criticisms are delay, the facilities in the courts, the circumstances in which litigation and court proceedings take place. Judgments are criticized very often, more so because of a perceived lack of quality of the decisions as opposed to influence. There have been, and it's a work in progress. Yeah, I think that this is, I may have given you a different answer 10 years ago or 15 years ago. There have been increasingly many cases where the courts have, there are increasing cases of litigants bringing public law issues to the court. Judicial review, constitutional cases, questioning government action, police action, institutional bodies action, and courts ruling in their favor. I don't think, and maybe I'm overly optimistic, that there is a general or even a significant feeling of influence either in terms of favoring the government or old school tie kind of influence. There was a comment about judges gone to school together and so on. I suspect all our judges now went to law school in the region. I'm trying to think if there are any who who qualified in the previous system. And so you have, generally speaking, counsel will be appearing before judges who they went to school with or who taught them. The results of so many cases, civil and criminal, don't support are influenced by way of connection kind of result. And I don't sense that that's a major factor. And obviously that's even less so for the reasons that Magali said when you come to the CCJ. But just at the local level, I don't see that as a major factor.
Before I get to you, Larry, just to follow up on that, Mike, is that sense of yours a sense by reference to the views of counsel or by reference to the views of the general public? And I ask that deliberately because we tend not to be driven by statistics in our region. So we very often speak in anecdotes. And the question, and I remember at the very beginning you spoke to the fact that much of your conversations around the issue have been conversations with counsel. So the question is there, because the problem, and I'm trying to get at, is that while as lawyers we may have a very healthy understanding of the system, how it works and the rest of it, very often as lawyers we can, without meaning to, become so lost in the clouds that we forget the public that we serve. So the question is it that the position you have relayed is one which may be considered, in and out of quotes, ignorant of public perception, more so by reference to what you understand to be the views of counsel, and that there may be a whole other avenue of exploration that needs to be had to determine whether the courts are serving us well at all, certainly at national level, even if not at the CCJ level.
And so it was intended to be not just counsel's views, but general public view, and of course, my knowledge of that is limited. I mean, my knowledge of what the public thinks is, A, being a member of the public myself, and having some level of interaction with non-lawyers. Yes. And also what I see in the media, what I see in media coverage of court matters. The criticisms tend not to be of that type. I accept that I'm not the best spokesperson for non-lawyers, but that is my view.
Yeah, Larry, I had some.
I often wonder why this issue of influence is an issue. It's a human being thing. It's not a West Indian thing, and so the people in London, they don't have issues of influence. So I go to Middle Temple or I go to Oxford or Cambridge, wherever, and I sit in a class with someone, so what? He or she appears before me, and then what? I am going to be influenced because we were classmates. I don't mean to sound, let me be myself. It's hogwash. It is nonsense of what my late father would call high-class nonsense. It is foolishness. What we are saying about ourselves, we should listen to what we are saying about ourselves. That is what is so disturbing. What are we saying about ourselves? That we cannot stand in judgment of ourselves because, I went to school at Harrison College, so I pitched marbles with Larry, so therefore, come on. We cannot divorce ourselves from that issue. And I think the argument needs to go beyond that. It really has to go to a level of what do we want to deliver for our citizens. At the end of the day, our clients are citizens. Whether at the private bar, whether at the public bar, it is about the citizens, our fellow countrymen and women. We want to make sure, in my view, that the widest cross-section of the society has access to justice. And fundamentally, that has to be what drives us. I just want to read something here that Dr. Lloyd Barnett, who's a well-known lawyer in this country, said in an article at 10 years about the CCJ. And he said, in preparation of this paper, I have been obliged to make a careful study of the CCJ judgments, particularly in the appellate jurisdiction. In my view, they are thorough and analytically sound, socially relevant without being insular, learned without being pedantic, progressive while being appreciative of precedent, culturally sensitive while appreciative of Commonwealth and international learning. Speaking recently to a distinguished English Queen's Counsel who has had much experience in the House of Lords, the English Supreme Court, and the Privy Council, he asked me, how were the discussions going in Jamaica with respect to our accession to the appellate jurisdiction of the CCJ? I think I said it is at a stalemate. He responded that he hoped Jamaica would delay the decision. I was taken aback as I had regarded him as liberal in the true sense. He then added, my reason is that while the Privy Council remains as your final court of appeal, there is a potential source of income for me. But I must confess that I have been reading the CCJ judgments and they are excellent. Enough said. How much longer are we going to loiter on the premises of the colonial master?
Yeah, I'm going to, I mean, we're way out of time in a sense. Shakira, I'm going to have your views on it before a final wrap-up question, but on that point of the fees, I have said, and it is true, that since in the UK, they started a disaggregation of the contribution of legal services to their economy, which contributes about 9% or so to their GDP. There has been hesitation in their desire to see matters move away from the Privy Council, or Russian matters move away from London, for another, if you want to go to that extent. But I'm going to ask you, Shakira, a similar view, again from your understanding, from your dealings with your peers. Are there any hesitations on the point of influence, regardless of what you may have heard any of us say?
Yes, one of the major, I guess, reasons why they would be in favor of retaining the Privy Council has been because they see the construct as being impartial. But I, on that point, would echo, so as not to repeat a lot of what has already been said, I will echo the sentiments of Larry in terms of we have to get to a point where we elevate how it is that we view ourselves, not only as a country, but as a Caribbean. I mean, it doesn't hold any weight now because, again, to not speak only anecdotally, if you want hard evidence that impartial decisions can come out of the CCJ or impartial judgments can come out of them, look at the judgments that have been released and look at the reactions of the attorneys in those matters, if any, and you will find your answer. I don't believe to continue to hold on to the idea that only the Privy Council can be impartial and only that court can produce impartial judgments is gonna carry us anywhere. I mean, it is a very real concern. I think one of the reasons why they share that concern is because they believe that the CCJ is a lot closer to home, and so they would be a lot more open to influence than, say, the Privy Council that is far removed from our realities. However, I would say this is where public education is important, because I know that the CCJ has done a lot to insulate its court and its judges from undue influence. So I think sharing more of that with the public, not just attorneys, but also persons who are possible litigants, the general populace, non-lawyers, would help them to form a more informed opinion or view on this particular point.
Just quickly. Australia, a similar hue and kind, have gone their way. New Zealand, a similar hue and kind, have gone their way. India, they've gone their way. Another quote from the article from that Sir David delivered. Lord Cook of Thorndon, a New Zealander who sat in the Judicial Committee of Privy Council for many years, wrote in a similar vein in the Commonwealth Lawyer, April 2003. In support of New Zealand's withdrawal from the Judicial Committee of the Privy Council that, quote, since 1987, I have been and remain converted to the view that the development of our legal system requires replacing the Privy Council. Judges in the United Kingdom, however eminent and enlightened, can only have a superficial acquaintance with New Zealand conditions and problems. They are of the same hue and kind. And I will end by just borrowing the words of Robert Nesta Marley. Emancipate yourself from mental slavery. None but ourselves can free our minds. That's
Thanks.
it for me.
Okay, thanks, Larry. Before I open the floor to questions, I want to ask, it's a pet peeve of mine, really, and I'll ask a question. And all I want is a yes or no. Nothing else. Nothing else for the minute. Is it worthwhile to have a well-developed and properly implemented system for ongoing review of our judicial branch? Peer review. Yes or no?
Yes. Sure. You must say yes.
Yes. Yes.
Absolutely.
So having said that, I think we now have a mandate to say that wherever we go, wherever we stay, there is in the public's interest something that requires that our judges, however important, however intellectually secure and strong they are, however robust they may be, must in fact recognize that they serve the public, and that if there's a method of securing public confidence, which could in fact include ongoing peer review, properly considered and implemented, it is something that we should strive for, and we should not resist it. So having said all of that, and having heard all the views, we now open the floor up to some questions, and then we will, and including from the online. Are there any burning questions from here? Andrew? Odisha, yes. Where are the mics? I'm not seeing them. Odisha will assist us. But in the interim, I'm going to, one question was sent to me, at least a couple of them actually. But there's one which said, I'm not sure what it is, from someone who said, the CCJ, I believe, should be the regional court, but customer clients should be given the Privy Council as an option. I'm not sure what that means. So that brings about a question of a regional court with an option to the Privy Council. And I suspect the short answer to that, without even the panelists getting there, is that that could not make real sense if you're talking about a judicial system that works. But there are a couple of hands that have been up, and Dougie Lays, I see you there as one of them.
Yes, thanks. Thanks, moderator. I have one question, and it's really a follow-up to what Mr. Hilton had said concerning the issue of the right in the Constitution to appeal to the Privy Council. Because, and I've written on this publicly, but I just want to echo that sentiment and ask a burning question. Because from my own perspective, the Constitution gives a right in civil matters, once the matter is, subject matter is over $1,000, to a right to appeal to Her Majesty in council. Yeah, a right to appeal to Her Majesty in council.
We're hearing, Doug.
Okay. Now, where we are is that the Privy Council has introduced this new procedure of a filter, in that you now have one judge, and Mr. Hilton has put in the additional, which I wasn't aware of a 3-judge panel, and you have to show reasons why. Whatever the enhancements to it, my view is that that's an assault, an attack on the Constitution, because it says of right. And the Privy Council may well have good intentions in doing so. And I remember when I used to appear before them, there are a lot of matters coming before them where you can see they were uncomfortable with the matters because they lacked merit. And if I recall, I think, Mike, you at one occasion, they had asked you, is there some way in which we can have filters in the local courts getting these matters before them? So, point I'm making may be well-intentioned, but that's not the way to go about it, because the Privy Council exercises their procedural jurisdiction, as I understand it, by virtue of the procedure rules under the Judicature Act, and then there is a local procedure rule. Now, this is a constitutional provision which is at the top of the hierarchy. How can the Privy Council be undermining the Jamaican Constitution, affecting the rights of Jamaican citizens in such a manner. Their actions are really ultra-vires the Constitution, hence my question. Who is defending the Constitution while the debate rages on? And I don't see the Attorney General here, but I would imagine that's a question for the Attorney General and one which he should answer or take it up with the Privy Council for a declaration. I think I've said enough.
I don't say I have the same concerns that you've expressed, Douglas. And you're right. One of the judges did raise that question in a matter that we did. I must say I have never been happy with the as of right being the way it is written. There are some things like constitutional cases which could justifiably be as of right. I don't think an apex court should be hearing matters as of right just because of how much money is involved. It's a personal view. But the Constitution says it. And our court, applying our Constitution, can't ignore it. And my answer to them then was, it is something that our Parliament and our people dealing with the Constitution should look at. And it's an opportunity, you can say it in a judgment. You can put in a judgment, you invite the persons who deal with these things to consider this, but you can't just ignore it, which is what they've done.
Fine. I saw Matthew. Yes.
I have a concern which, well, I think puts me at the opposite spectrum from most of the views expressed so far. And because of that, I'd ask that you permit me to preface my concern just a bit. In 2016, I sat on a panel much like this one, offering full-throated support for accession to the CCJ for many of the same reasons mentioned, the mechanical reasons, access to justice, the likelihood of more appeals, as well as some of the social and cultural reasons that have been expressed. Since 2016, there have been 2 decisions by the CCJ in 2018, which, if not completely dissuaded me from accession to the court, at the very least gives me great pause. The first is the court's decision in Nervase, and the second, which applies Nervase, is the decision in McEwen. The effect of these decisions is that the court radically transformed what we have always understood savings law clauses to mean and do, and circumvented the efficacy of those clauses to come to particular conclusions. And I am concerned that these decisions show insufficient deference to the policy preference of the local legislature and a concerning level of activism by the court. And that concern is viewed in light of 2 contexts. One is the separate judgment of our keynote speaker in the Nervase decision, which I will associate myself with his reasoning, because he also disagreed with the court, the majority in Nervase, and adopted an entirely separate rationale, a separation of powers rationale in coming to the same conclusion that the majority did, which shows that there is a far more jurisprudentially plausible reasoning that could have come to that conclusion that, in my view, demonstrated better judicial restraint. And so if the majority opted not to take the more restrained approach, it, in my view, underscores this concern about driving policy as opposed to giving effect to local laws. And the second aspect of my concern is the, in some respects, subtle preference for a court that drives policy as opposed to applying law. And I think there's a distinction to be made between the development of jurisprudence, which I think is appropriately the role of an apex court, and the selection of a specific policy preference. So
I share my concern for your specific comment. Are you also concerned that the court's jurisprudence shows a tendency towards an activist court, much in the way of how the Supreme Court of the United States is perceived, as opposed to a court that applies law? And that's the concern I should share.
Larry, you want to take that?
I understand what you're saying. I think, how we are taught law is that law changes happen incrementally. And I get that. That's how we are trained. But as a lawyer who deals in constitutional law matters, I don't call it an activist approach. I rather call it a very progressive approach. And I see nothing wrong with it, quite frankly, because, for example, the Section 11 rights in Barbados, which were normally seen as a preamble, are now justiciable based on the decision of the CCJ and Boyce and Joseph. So I love that, because now I get to argue the right to liberty, the right to security of the person, the right to life as separate issues, the right to protection of the law as a separate issue, which gives an opportunity for the court to either expand or it can choose not to expand. But what it allows for the argument to be made. And I think that, we must be careful that judges are human beings too. I think I realized that only about 12 years ago. Judges are human beings too. So that sometimes they may get it, what we may think that they have gotten it wrong. And I happen to think that every case that I have lost, that the judges got it wrong. Because that's just my view. I hate to lose. But the reality is, part and parcel of what we do is that sometimes the court will be with you, and sometimes the court is not going to be with you. It is part and parcel of what we do. And I don't think we throw out the baby with the bathwater. So you get a decision which you're not necessarily fond of, which in my case happens to be all that I've lost. So what do? Do I go and look to become an engineer, or go and teach? Or do I say, okay, I've lost this one, so I saddle up my horse and I go again? So we must be careful with the perspective that the court is activist. I think the court is perhaps specifically unique to our experiences. And I think that is something we have to bear in mind, that while we don't throw out that which is colonial, because we do have a colonial past. Nobody can sugarcoat that. But I think if we are trying to chart our own course, some things may seem radical, but it's only radical because we've only known the other stuff. So, yes. Oh, they want me done? Hold a second. I'll defer to my senior. Hold a second.
Intervention. I'm so pleased with the question. I do have a difficulty with the label activist court, but I don't think that you can say or should say that this is a CCJ thing compared to a Privy Council thing. If you look at the Privy Council of the Stein-Hoffman Privy Council 20 years ago, and compared to the Newburgh Assumption Privy Council in recent years, a totally different court. That was an activist court in the early 2000s. It's a much more conservative court now because of who is sitting on the panel. The present CCJ court panel is very different from the Delaware-Steed panel, just because of the persons. It's not a court issue, I don't think. And we can have the debate as to the level of activism or progressive approach the court should take, because that's a very good debate. But I don't know that that's a debate that ought to change your view on accession.
I'm going to take 2 final questions. 3 in fact, but you have to be short. AJ? Yes. Yes. We're not hearing you. We're not hearing you.
Good evening, everyone. All right, so my question is, I'm a student, and this has been an issue that we raise in constitutional law. And with all the salient reasons that have been passed about why we should move to the CCJ, I'm yet to understand what is this holdup. Like, I've done my research, and I'm like, okay, these are good reasons. Now, what next is it that we should do? I can't understand, like, why are we not making the next steps? What are those specific protocols? Are there some specific protocols or things that we should do to move to that next step? What is this holdup? Because we all agree, I assume we all agree that we want to move to the CCJ to be our final court, or most of us do, and I want it.
I'll quickly take a stab at that with my moderator's privilege. The minister is here, and as Mike had indicated earlier, there's a process that is being engaged that could lead to that step being taken. And so the short answer to that is there's a process to be engaged, there are procedures to be followed that is being engaged. AJ? Yeah, the mic is with you now.
Right. This is not a question. It's a comment. The panel has really zeroed in on access, which that's a principal issue. But I really don't understand, just like the speaker before me, I don't understand what's the hold-up. Look, the highest authority in the United Kingdom have told us that we are not welcome in their court. Larry mentioned it. The first president of the Supreme Court. He told us it's public knowledge, and they have not retracted it. They have said we are not welcome. Now listen to me now. I'm in the winter of my years. I am a descendant of slaves. I don't want any person in the United Kingdom to tell me that I must leave, and I sit down and don't leave. And what is worse, it's not that we have to go and find somewhere else to lodge. We have a house that we have paid for. And what is more, that house has been lauded and accepted internationally. So who am I? Why am I loitering? As Laura reminded us about the Prime Minister, former Prime Minister of Barbados, how we put it. And the issue, with the greatest of respect, is simple. The people in the United Kingdom said they don't want us. Well, why are we telling them that we are not leaving? The 23% that the polls have said that they don't want, they would prefer to stay with the Privy Council. That's not, they can't say that. The Privy Council say you cannot stay. So all this thing that we are talking about and going around, and with the greatest of respect, it's one issue. We have to leave. We have overstayed.
All right, AJ, thank you very much. Carla, or is Jacob ends it? Not you, Carla. Jacob and Carla, but I give you 5 minutes in total. Not 5, 3 minutes in total, frankly. 3 minutes in total. Jacob, you have a minute and a half.
Thank you. I
First of all, I want to thank the panel and the moderators for your time today that you've given to us so kindly. I'll keep my question brief. I think that there is an A and a B to it, but so the A part of my question is whether there is whether any of the panelists have a concern that sections of the CCJ Judicial Code of Conduct, particularly I am thinking of section 5, which speaks about judges not holding any irrelevant considerations or being associated with any group that holds irrelevant considerations. And included in that is definitions of sexual orientation and gender identity. So the A part of my question is whether there is a concern that that requires judges who sit on the CCJ to hold views which are inimical to parts of our Constitution that are saved on purpose in 2011 by the committee that sat to revise the Constitution. And I don't know and then the B part of my question is, let's say that it does require them to hold views that are inimical. Is there a necessary effect? Would that have any impact on whether Jamaica can accede to the CCJ?
Mike, you want to answer that in a couple of seconds?
Yeah, I think absolutely the answer to your first question is they can hold views, just as anybody can hold views. But I expect them to do what they have done, which is rule based on the Constitution or the law that they have to interpret. If they're doing a case from Jamaica, they're using the Jamaican Constitution, and they have to respect and apply the law based on that. And the same when they're doing a case from Barbados. So I don't have that concern. And in terms of your B question, I don't think at all that ought to affect. You said whether Jamaica could accede. And I think that it would need to be a situation where you had clear reason to be satisfied that the court is going to pass or is going to rule in a way contrary to our Constitution for us to say we're not acceding on that basis, which I don't think is the case.
Yeah, Carla.
Okay. So one of the things that in my research I've seen is that an Achilles heel for the region is that we do not write. We do not do the kind of research, provide the kind of information that can help and continue to grow the jurisprudence. So, in as much as the court is there and it will use what it has at its disposal, which it must, that is great. But this is a plug to all of us who are within the legal profession to play our part in advancing the work of the CCJ or any other place for that matter. We cannot go to our graves with all the knowledge, experience, information that we get, and we do not curate it and put it in a place where it can assist the very court that we are here talking about going into. It's a plug and it's an ask.
Okay. Sorry. Yeah.
There who said about holding a particular view. We must be confident enough in ourselves to be able to have a particular view about something, but to be able to follow the law. And I'll just quickly give you my own personal experience. When I did the Gibson case, he had done some stuff which I didn't agree with. And I remember saying in chambers, I am not applying for bail for him. This is nonsense. But my colleagues quite rightly said to me, that is not your call to make. There's an application for bail to be made, a valid application. If you are counsel, you got to make the application. I made the application because that is what I was called to do, and that is what my oath tells me I needed to do. So this notion about holding views, we all have views about all kinds of things. That cannot be a basis upon which we don't accede to the jurisdiction of the CCJ in its appellate jurisdiction. That doesn't make any sense to me, no disrespect, but I don't see that as a basis, quite frankly. Thank you.
Right, thank you. And, no, we're absolutely out of beyond and everything having not to do with time. So let me say at this time, I want to thank the discussants. We could go on forever, really, literally. But unfortunately, all good things must come to an end. And I will give upon my moderator's conclusions that I would have made in the interest of time, knowing that Dave will do us very well in concluding and offering a vote of thanks.
All right, thank you very much, Chris, and thank you to our discussants. Chris handed over to me to do well in the summary, and I had some amazing notes that I took, but it's 7:37, and you were all here, and so with that, I would go to this. I think it was very interesting. A comment that was made and a question that was asked. A comment that was made by Magali was in relation to our apex court being able to ground argument in policy. And I juxtaposed that against the question that was raised regarding the issue of having an activist court. And as we went down that direction, we went to another issue, which is, what's wrong with having an activist court? And do we get or not get an activist court depending on whether we pick one or the other? Or is it more dependent on the persons who sit at the particular point in time? And so perhaps that is not the issue that should define the choice, but a choice we must make. And for so long, we have meandered around the issue. And so we had a couple impatient questions that were raised at the end, which is, what's taking so long? Why are we not taking the next step? Our discussants have really outlined to us that we have been, as A.J. Nicholson has said, asked to leave. And we have a house to go to, and it's a good house, so why don't we go there and live? And so I believe we have had a rich discussion. We may not have had a fulsome presentation, Minister, of the arguments against, perhaps because we had more of the 59% here than the 23%. But we did have some attempts to explore what some of those arguments were, even if in rebuttal. I did see on the website of one of our colleagues in Trinidad and Tobago, Dr. Claude Denbo, an interesting presentation, and I see Lisa Campbell nodding, of the arguments, the pro and con arguments. And it was interesting. Clearly, it was written some time ago, because the conclusion comes to this. At the end of the day, it is anticipated that the debate as to the pros and cons of acceding to the CCJ will continue. Having regard to the unique and complex nature of the ever-changing political and social landscape in Trinidad and Tobago, where the court is based, it would not be surprising if that debate is still going in 2020. Well, here we stand in 2023. I think we're a little ahead of where Trinidad and Tobago is. But clearly, at that time, the court would already have had the leaders in Barbados, Belize, and Guyana, and the follower of Dominica. And since then, of course, we have had St. Lucia. But the question is it not now time? And clearly we will have to, I think, make a decision one way or the other as we proceed through that process of constitutional reform, in which this is but one issue. Now, as a moderator, of course, I'm not forced to get back into the debate. I am here to end it, and not end it with a conclusion, but to end it with appreciation for those who have participated in the debate. And we have named all of those names already, so I will not repeat those here. Instead, I will move on to express appreciation to those who have enabled it all to take place, who we are not seeing on a platform or on Zoom or on the stage at this time. Those would include our accommodation partner, Spanish Court Hotel, our media partners, UE Media and Business Access TV, and Business Access TV enabled this event to be streamed, I understand, across the Caribbean region. Appreciation also to the staff at the university and Mona Law, and I would mention here Ms. Marjorie Henry, Mrs. Arlene Supersad, who I personally must thank because she's the one who kept me organized, Ms. Odisha Coates, Mr. Andrew Hutchinson, Mr. Ismail Preston, and the IT team from MITS, Mr. Norman Haywood, the director of the security team, the marketing, recruiting, and communication representatives, Maze Catering Service, and you will be invited afterwards to partake of the refreshments outside and to mingle. The UE Maintenance Department and the Class of 1997 Planning Committee comprising Ms. Laurice Cadogan, Ms. Lisa Campbell, Ms. Hillary Reed, Ms. Janice Nelson Brown, Ms. Carla Ann Harris Roper, Mr. Christopher Townsend, and Dr. Christopher Malcolm. And I especially thank them because I came to moderate a session that really went very well, even though I had nothing to do with putting the agenda together. And finally, of course, I thank you, the attendees, for your attention and for your participation. And with that, I'm just looking to make sure I didn't leave out anybody and nobody is giving me any signals. So it looks like I didn't. And with that, we bring this session to a close. Thank you much, everyone.